129,293. Donald Quayle, I believe, Queal, and others versus Ronald J. Loftus and Patricia Lynn Loftus as trustees. Counsel for the appellant?
Yes, Your Honor. Thank you. Hannah Moltz appearing on behalf of Ron and Lynn Loftus, trustees of the Ronald and Patricia Lynn Loftus Trust, who also appear in person. And I would request to reserve 3 minutes for rebuttal.
3 minutes? You've got it. And I warn you, you saw what happens when it gets down to a minute. It goes crazy.
Yes, Your Honor. I'm bracing myself.
Yeah.
This case involves a disputed tract of approximately 5 acres between a surveyed section line and an existing fence. The record shows that a survey was conducted in the course of this litigation that showed an existing fence lying west of the section line. And the section line is the described boundary in the deed bounding the properties owned by the Loftus parties and owned by the Queal and Hiddle properties. My clients, the Loftuses, purchased their ground in about 2002 and have continuously used the property up to the fence for agricultural purposes. And we described the area between the section line and the fence in this litigation as being called the disputed tract or the disputed property. And that's how it's referred to throughout the record and in the briefing as well. The fence has been in the same location since about the 1960s. And Mr. and Mrs. Loftus or their predecessors in interest were the sole users of the disputed property openly since at least that time, since that fence was constructed. Mr. Hiddle, this was included in the record, watched Mr. Loftus rebuild a portion of that fence at one point in time and did not ask that it be moved to a different location. Mr. Hiddle was aware of Mr. Loftus's actions, saw Mr. Loftus building the fence, even spoke to him while he was building the fence, and didn't ask him to move it to the section line or state that it was not on the legal boundary line. And we do believe that that is an important part of this case.
Now, is Mr. Loftus using it for farming, the area for farming too?
Yes.
Okay.
The ground on both sides of the fence is used for agricultural purposes.
I'm just trying to understand how these two, what's in it for, I mean, what's the bottom line for these 5 acres? What caused these two people to get in such a row about this?
Yes, Your Honor. I do understand that question.
What's going on here? It seems like there's something else going on.
What blew up?
Yeah, what blew up?
Yes. So from my client's perspective, Your Honor, they had used all of the ground all the way up to the fence since their purchase, believed that that was their ground and operated it as such. They've made every attempt to be good neighbors over the years. They have a generational agriculture operation, and that is important to them that they be good neighbors, and they had a good standing relationship with the Hiddles. And then some of the Hiddle ground changed hands. Mr. and Mrs. Quayle purchased that ground. And then a dispute came up about the location of this fence. They did make good effort to try and resolve that among themselves. But then that broke down to a point where the parties both are pretty entrenched in their belief that they own that disputed acreage. And that's what brings us here today.
Back when I started the practice of law, I did a lot of property cases. And it was always our standard then that you acquire property in 2 ways. You either buy it by agreement with the owner, or 2, you gain it through adverse possession. How did your clients fare? Which one of those methods did they use in this case?
Your Honor, they believed that they purchased it, but our argument to the court today, and that we have briefed, is that they now own it by adverse possession. We briefed this as 2 different arguments.
The court didn't agree with you, though, did it?
They did not, Your Honor. We believe that they had an
When did the court get it wrong?
Yes, so I'll speak to that on the adverse possession claim in particular. So we argued this case saying that the Loftuses had a good faith belief of ownership in the property up to the fence line. The court that found that that was not an objectively reasonable good faith belief of ownership, because I'm just going to throw out section numbers here. The property is section 13 and my neighbor's is section 14. That's obviously going to be a straight north-south line adjusting for the curvature of the earth. The judge said, well, this fence makes some jogs around some natural obstructions or around some trees. And so the district court found that there could not have been an objectively reasonable belief in ownership of that because irregularity of the fence didn't match with what a reasonable person would believe that section description to be. Now, it was established in the record that the Loftuses never actually laid eyes on that portion of the fence until about 5 to 7 years prior to this dispute. So we believe that the district court got it wrong in stopping its analysis at that point. This is an issue that we did brief to the court here, that the adverse possession statute allows for adverse possession under a good faith belief of ownership or possession that is adverse. And we believe that at the time the Loftuses became aware of that jog in the fence, their good faith belief of ownership then transitioned into a possession knowingly adverse. We think that the district court erred in stopping its analysis at that
Didn't the
first step.
judge, though, didn't he point out that, or didn't the judge in the case point out that there was two different types of testimony for your client? That in the deposition, he said one thing, but then he said something else later. And so didn't the court take that into consideration as well?
About their belief of ownership?
Mm-hmm.
Yes, they did.
Well, and about knowledge of the fence too.
Knowledge that the fence wasn't on
Yeah,
the property line.
yeah.
I don't recall that specifically, the difference in deposition testimony as related to the trial testimony from my clients.
So can I go back to the first, Judge Hill's question about you either buy it or you have adverse possession. And you said your client's first position is that they bought not the standard line, but they bought it according to that jogged fence line. Was there something, I mean, they had a meat and bounds description when they bought the property, right? How could there have been
And yes, Your Honor, I'm sorry that I wasn't clear in my answer there. So they believed that they bought everything that was fenced in. And then once, our argument is once they actually saw that irregularity in the fence, they still believed they owned that.
okay, but so there was no survey done or anything when they bought the property?
That is
But
correct.
the property that they bought there's no allegation that it wasn't properly described as set square tracks and they
That's-
just didn't check it out.
That is correct,
Okay.
Your Honor. And we believe that is, that does not defeat their claim of adverse possession here. I think there is significant case law to say that notice of a defect in deed or by survey later does not defeat adverse possession.
Okay.
So we do believe that is our strongest argument here. The statute does not say that the claimants have to maintain the same mental state for all 15 years. It says that possession may either be under a claim knowingly adverse or under a good faith belief of ownership. The Loftuses possessed the same tract continuously from 2002 until today. There is no dispute about that. They have been the exclusive users of that property since that time.
I've got a question about, was it their belief that they owned the property to that fence line?
Yes.
Did they believe that that fence line was on the property line?
Your Honor, they didn't give that any thought. And I believe Mr. Loftus testified to that at trial. And that was referenced in the briefing too, that even at the time he saw the irregularity in the fence, he didn't associate it with a boundary issue.
People build fences where they can.
Yes.
Sometimes you can't put them through a bog
Mhm.
or around outcroppings. You put them where you can, and fences are just fences. They may not necessarily be property lines.
That is correct, Your Honor. And that's kind of our first argument as well. The appellees argued that this was merely offensive convenience, and that is what the district court found as well. But we argue that even if the original fence was placed for convenience, later conduct can create or confirm an implied agreement that the fence should be the boundary. And that is a separate and distinct issue from the adverse
You're
possession.
saying this record contains sufficient evidence of a mutual agreement that that fence line was the property line.
We believe that it does, Your Honor, specifically from Mr. Hiddle's actions when Mr. Loftus was tearing down and rebuilding a section of the fence. Appellees rely at length on Mr. Hiddle's testimony in their brief that the fence was offensive convenience. He was told by his grandfather that there was an agreement between the parties that this was the fence was placed in this location for convenience, for ease of construction and maintenance, and that in the future, assuming better technology and machinery would be available, that if the fence had to be rebuilt, it would be placed back on the property line. That event actually did happen. Mr. Loftus did go tear out part of the fence, rebuild it. Mr. Hiddle saw that. He actually went and spoke to Mr. Loftus when he was constructing that portion of the fence and never said a word to him about the fact that the fence should be moved or that it was not built on the property line.
But wasn't the agreement that it'd only be, if the whole fence was replaced, they could replace parts of it?
I don't believe that there was
Okay.
specific testimony that they would only move it if the whole fence was replaced.
Okay.
And so it's our position that Mr. Hiddle's private belief or his private knowledge of an agreement cannot defeat his outward actions in his discussions with Mr. Loftus and in his failure to stop Mr. Loftus or advise him of that issue or his failure to defend his title to that additional 5 acres.
Okay, I'm trying to put this in perspective that a city girl like me understands. So I have a yard and my backdoor neighbor and I build our houses at the same time. And there's a little creek maybe that runs through the backyard. And we agree that the fence will be on one side of the creek that actually gives my neighbor less property and me more property. Because that little creek, you can't put the fence in the middle of the creek. So I now have more property than the meets and bounds description would attest to. And we all agree that we did that because of the water running through. Then at some point in time, I repair that waterway so that it's not water anymore. And I put in plantings and a concrete fountain or whatever in that area and continue to use it as that, even though that impediment isn't there anymore. Then under that situation, you would say, but it's open and I did everything on that piece of property to treat it as my own, even though we may have known in the beginning. I mean, is that the same kind of thing we have here? I'm just trying to, it may be a stupid example, but I'm just trying to.
Yes, Your Honor. On the adverse possession question,
Right.
That's what I'm going to address here. So there is case law that states permissive use cannot ripen into adverse possession. So the permission was granted to you. The agreement was
The permissive use
cannot ripen into adverse
cannot.
possession.
Okay.
Specific to the person to whom permission was granted. And most of the case law on that point is a holdover tenant, not so much an adjoining landowner. So
if I sold my property and a new
Yes.
person owns it and they continue to treat that as their own, then that could be an adverse.
we believe
Because
so.
we don't have the same parties in agreement.
Yes, Your Honor, particularly at the time of that fence rebuild. We believe that is Mr. Hiddle's showing that he no longer intends to move the fence, or that agreement that the fence would be placed back on the section line were it to ever be rebuilt, that is no longer the understanding of the parties. He's the only one with that knowledge and
Their
he's not acted
understanding
on it.
change, or their agreement could change.
Yes,
By their actions.
yes.
As evidenced by their actions.
Any other questions? All right, you still have your rebuttal.
Yes, sir.
I'm
Thank you.
just trying to understand. Okay.
May it please the court. Alan Gehring on behalf of the appellees,
Mhm.
Donald Quail, Donna Hunter Quail, and Dan Hiddle. I think in response to your question, Judge Arnold Berger, part of the question or part of the answer would be, how long did the successive owner continue to possess the property? Did they occupy it for 15 years, believing they owned it? In the case at bar, the Loftuses only knew about the irregularity in the fence, they said, for 5 to 7 years. They didn't have it and possess it for 15 years under a claim of right because they didn't even know it was different boundary than meets and bounds or by a section line. that's something that could have been readily available through a Google map or any of a number of devices that are available to landowners nowadays. They could see where the property line was and they could see the fence. Well, I think a person ordinarily would say, well, that's peculiar. Why is it that way? There's nothing in my description that says it's that way. And in this case, they didn't assert that they owned it. They said until 5 to 7 years because they weren't even aware of it. So how could they reach the 15-year threshold?
I was interested in the district court's finding that there was no mutual agreement. Could you explore that with me?
Well, at what level?
Well, there was no mutual agreement that that fence was going to be the property line.
Correct.
Explain that to me.
Well, if we could go back to Mr. Hiddle and his testimony in trial that his father and grandfather were there on the property, and the agreement was, and he said that, well, he was upset about that. Well, why is this particular 90-degree angle, this jog in the fence, why is it there? Because he said it upset him a little bit, thinking that part of their property was not inside their fence. And his ancestors explained to him that that was a matter of convenience. It was done because of the obstructions. In this case, there is a bog that goes straight north of where the line would ordinarily go. And by taking that 90-degree turn and then continuing north, the parties simply agreed to go outside of the customary boundary.
And was there any dispute about that
No.
ancient agreement that everybody agreed that that is what?
There was no challenge to the testimony of Mr. Hiddle. I'm not
Okay.
sure there was anybody alive that would have been able
Right.
to testify to
I'm
that,
just
but
wondering how that came in then, but
yes.
so there must have been acquiescence or something that is the story.
Well, yes, and under the hearsay
Right.
exception, it comes in, and we cited that to the judge at the time an objection was made.
Oh,
The
okay.
practical effect of that, does that change title? Does that grant title to some other party, or does it
Well,
just, is
No,
it just an agreement?
it's just an agreement to place a fence in a particular location, and a fence is not necessarily a boundary. In this case, it wasn't the boundary. It was
Because
simply a fence of convenience placed there because of the geological situation, the hydrological situation, or whatever the case may be, that prevented the fence from being built on a straight line.
this is not the first case that has shown that fences are built where they can be built.
Well, and it's particularly true in Barber County where this case arose from, and where we have canyons and buttes and plateaus, and we have ravines, and we have areas that are very treed where you have these kinds of obstacles, and people construct fences to get around those obstacles, and it's all a neighborly accommodation. It does not rise to the level of adverse possession because no one thought it was adverse, and it wasn't adverse. It was an accommodation. It was go along to get along.
So what was the testimony as to when the Loftuses realized that the fence was not
The,
the boundary
that was found at page 134 of the transcript.
I just want year.
And when it was stated that it was 5, 6, 7 years ago that he became aware of the jog, which would have been 5, 6, 7 years prior to the
The
filing of the lawsuit.
Okay. And so can you adversely possess something that you're not aware?
It seems to me you have to have some claim of right to it. And why would you claim a right to it if you don't know you have it?
Okay.
And
So
I
that's
think,
where you're saying we don't even get to the 15 years. There's
no,
no
we
way
don't
we
get to, we don't get to 15 years. And then you get to the other elements that came out in the trial, which was that Mr. Loftus offered to buy it. Well, you don't offer to buy something you already own, for one thing.
And things had apparently already gone south by then.
Things have started to go south. You don't give somebody the permission to tear out the fence and bulldoze the trees to build the new line straight north of the ending point, and then still claim you own it. And it was only after the return from Italy that they became aware that it's, oh, wait a minute, maybe we own that. Maybe that's adverse possession. That's, the continuity is missing, the continuous claim. You can't claim you own it one day and then claim you don't the next, and then somehow all that can sort of stack up to 15 years. The court pointed out, the trial court pointed out how, adverse possession is a strong, high burden of proof. And it must be clear and convincing. And every presumption is in favor of the holder of legal title. Every presumption. In this case, we have maybe some doubts about some elements of the testimony, or some beliefs, or the building of a small portion of the fence on the very north end, rebuilding of it. So what? The trial court found that that was not sufficient, that was not credible, and that it was not under a belief of ownership. And that's the key under the second element of 6503. It was not objectively reasonable. They had the deed description, which contained no irregularities that would accommodate for that 90-degree jog. They had awareness only 5 to 7 years prior. They authorized the clearing of trees and the construction of a fence on at least a portion, 300 to 400 yards straight north, and they offered to buy it. So 4 or 5 things that just fly in the total face of consistent and persistent claim of title. All those things were lacking here. And let's not forget that the trial court, with the consent and agreement of both sides, personally inspected the property, saw the lay of the land, saw the need for the accommodation for why that fence was built, where it was. And the court heard the testimony of the witnesses. And after eyeballing it and considering it,
The
determined.
judge went out there, right?
Actually, yes.
Yeah.
Yes, and both plaintiff and defendant were there too when the judge was looking. So, we have all that as well. And, no, the judge didn't take a video camera or record, but he saw it with his own eyes and could certainly assess the believability of the testimony that he heard at the trial and relate that to the facts on the ground. Okay. Anything else?
I had just another factual question
Yes.
to help understand this. So the bulldozing of the trees, so that was your client who said, I'm gonna, tell me how that came about.
Well, there were discussions with Mr. Loftus, and the agreement was that they would go straight north of that northeast point before it takes that west,
Just because they decided to,
because a new fence is being built, and all that new
the
fence
whole,
south.
the all new fence? Or
Yeah, all that
Okay.
fence south of there had all
Okay.
been constructed new, and it stopped right there where that crazy 90-degree
Okay,
angle.
so where
took-
this
took
whole
off.
issue comes, so.
Yes.
So
The
he
agreement was, okay, go ahead and go on north of there. He moves in there with the equipment. He
and
takes out
did
the
he
trees.
realize that they were gonna be tearing up trees and all
Yes,
that?
there wasn't any question. And he came back out and saw it. He talked to Mr. Quayle. He talked to Mr. Quayle's assistant. He's totally happy. This is great. I see you've
New
talked,
fence.
you've gotten rid of a bunch of these scrub trees that we don't like, the locusts and what have you we don't like. So yes, he likes it. And then the plan is that the fence builder is going to go ahead and go in there, but unfortunately, the fence builder, who had planned to go to work there within a day or two or whatever, could not get to work on the job. He had another job he had to go to. In the meantime, the Loftuses have an epiphany that this is adverse possession. Apparently, while they're in Italy, they come back to their ranch and say, wait a minute, we own this. It's adverse possession.
Okay,
So that was the sequence of events. And then the job stopped, and so court, and here we are. So yes,
you
it's,
still have half a gap in the fence there? or what?
Well, it's kind of held together with some baling
gum.
wire and some, so there's some electric wire that holds cattle in from one side and from the other, but
Well, the
it's
fence
not
has been there
ideal.
65 years. I guess it can stand a little longer.
Well, part of that old fence got torn out and so it was torn out. So they went back with an electric fence on a temporary basis while this matter winds its way through the courts.
Okay.
Thank you.
Any other questions?
No.
Your rebuttal, counsel.
Thank you, Your Honor. To address the discussion that was just had regarding the trees specifically, if, as noted in the trial court transcript from the bench trial, that timing, the discussions, the back and forth nature of this was discussed at length, specifically in Mr. Loftus's testimony. And what our position is, and this is what's shown in the trial transcript, it's clear that Mr. Loftus agreed to the construction of a new fence. He agreed that trees should be removed. But once he went out and saw what had been removed, he realized his misunderstanding about the location of the tree removal as it related to the old fence. He was mistaken as to where the new fence line was going to be. And so as to that, and as to the comments about Mr. Loftus's offer to purchase that ground and how you don't purchase something you already own, our response to that is that that occurred after the dispute surfaced, and we believe that that should be viewed as settlement or practical negotiation, not as a waiver of title, because we believe that title was already vested in Mr. Loftus by reason of adverse possession. And it's,
And how do you get to 15 years?
yes. So Appley's stated that, Mr. Loftus can't, and Mrs. Loftus can't get to that 15 years. They didn't even assert that they owned it until 5, 6, 7 years
Right.
before the litigation. And we believe that that's simply not true. This was fenced in, and Mr. Loftus testified that he used this ground for his cattle. He turned cattle out on this ground. They grazed all the way up to the fence from 2002 until today. That is assertion of ownership. And I think we're getting away from the plain reading of the adverse possession statute that requires open, exclusive, and continuous possession of the property for a period of 15 years under either the claim knowingly adverse or a good faith belief of ownership. Mr. and Mrs. Loftus have done all of those things. They have possessed that property all the way up to the fence openly, exclusively, and continuously since 2002. They reached their 15 years by sort of tacking the two theories of that possession. For the last 5, 6, 7 years prior to litigation, their possession has been knowingly adverse. Prior to that time, it was under a good faith belief of ownership.
Prior to when it was under a good faith belief?
Prior to that 5, 6, 7 years ago marker when they became aware of the jog in the fence
And
line.
one of the things the district court found was there's no way you would have a good faith belief that
After seeing that,
right after seeing it.
yes,
Okay.
yes. Okay. So we've discussed at length the adverse possession nature of our claim here, as well a little bit about the acquiescence and agreement to the fence line as the location of the actual boundary between the properties. We believe that those were two errors from the district court and would ask this court to reverse the decision and quiet title in the Loftuses under either an agreed boundary or adverse possession theory. Thank you.
Thank you.
Thank you, counsel. I think that concludes our arguments this afternoon.